matter that, at the time, she had no way of knowing how much male managers earned. Ginsburg, in dissent, pointed out that the court was requiring women suing for pay discrimination to do the impossible. The ruling against Ledbetter was so obviously unfair that Congress overturned it with the Lilly-Ledbetter Fair Pay Act, the first law Barack Obama signed as president. If it seems that the court's five-justice conservative majority has been twisting the law to rule against employment discrimination victims, there is a simple reason. It has. The court's battle against victims of on-the-job discrimination is, however, part of a much larger war. For 5 decades, the court has, with striking regularity, sided with the rich and powerful against the poor and weak, in virtually every area of the law. In campaign finance law, it has opened the floodgates to money from wealthy individuals and corporations. In election law, it has upheld rules and practices designed to make it more difficult for the poor and racial minorities to vote, and struck down a key part of the Voting Rights Act. In corporate law, the court has made it harder for employees and consumers to sue when they are injured. In criminal law, it has favored prosecutors so consistently that it has contributed significantly to the nation's mass incarceration crisis. And on a wide variety of issues, the court has ruled, often cruelly, against the poor. The financial and emotional toll on the losing parties in these cases has been considerable. Jack Gross was devastated when the court manipulated age discrimination law to reject his case. "One of the things I have always counted on was the rule of law," he said. Gross was also upset that, in addition to losing the damages the jury had awarded him, he was out more than $30,000 in legal expenses. "That is money," he said, "that was intended to help my grandchildren get a college education so they wouldn't have to starve their way through, like I did." Ledbetter was crushed by her defeat, which she learned about when she was on the way to a church luncheon with her husband, who had been diagnosed with cancer. "I'd done what I could," she said. "Goodyear was simply a greater force than I could overcome." That was clear as day. Ledbetter had not only lost the damages the jury awarded her. It occurred to her that, because her pension and Social Security were tied to her salary, she would continue to be underpaid for the rest of her life. As shattering as decisions like these have been for individuals, in the aggregate, they add up to something much larger: a systematic rewriting of society's rules to favor those at the top and disadvantage those in the middle and at the bottom. The Supreme Court has played a critical role in building today's America, in which income inequality is the largest it has been in nearly a century. The court's decisions have lifted up those who are already high and brought down those who are low, creating hundreds of millions of winners and losers. It did not have to be this way, and there was a time when it was not. On October 5, 1953, Governor Earl Warren of California was sworn in as Chief Justice, and his arrival launched a progressive legal revolution. In his first year in office, Warren led the court to a unanimous ruling in Brown v. Board of Education, which held segregated schools unconstitutional. When the South rose up in massive resistance, the court did not back down, and it proceeded to integrate bus stations, restaurants, and other public spaces. The drive for racial equality was only part of the Warren Court's rights revolution. The court also recognized new rights for criminal defendants, including the right to an appointed lawyer for those who could not afford one. It championed the rights of non-Christians by banning official state prayer in public schools. It expanded the rights of the poor in many ways, including by adopting new protections for welfare recipients. The Warren Court was a powerful force for change, but a fragile one. There had been bitter opposition to its rulings every step of the way. The court had many enemies, including an Alabama congressman who complained that